Hello everyone, thank you for being still here. My name is Allemagne, and I'm the head of the Legal Advisory Committee at NationalSecurityAlliance. If you're still here, I guess that you have some interest into biometrics for B2C and B2B implementation. If so, you may have been told already that biometrics processing, matching, storing, collecting is regulated. And so you can do whatever you want with biometrics. What I propose to you today is to have an overview of the applicable law in Europe on biometrics, and then to see how we can build trust and confidence in biometrics. I think you know already biometric data or personal data because they allow to identify a data subject. So data protection law apply, and you will have a set of principles and obligations a data controller will have to enforce to protect data subjects' privacy. At the European level, you will find the 1999 directive, which provides all these obligations and principles for member states in order for them to transpose at the national level, at the harmonization in European Union. As an example of principle I'm talking about, you have fair and lawful processing, which means the processing of your data, here per biometric data, should be authorized by law, or you should get the consent of your data subject, or it should be for the performance of a contract, and so on. Another principle is a specified purpose. When you decide to process biometric data for one purpose, you won't be allowed to do further processing in a way that is incompatible with the first purpose. Your processing should be adequate. It means that data are adequate and relevant and not excessive for the purpose you want to reach. Your data must be accurate. Your retention period shall not be longer than necessary to reach the purpose. Your data should be protected from unlawful processing, accidental loss, destruction, damages, and your data subjects, so users, for instance, clients, have some rights they can enforce, such as right to access the data, to modify them, to get them erased. However, if you take the directive, 1995 directive, you won't find a line about biometrics. In general, you won't find anything about very specific type of data. That means that for any processing of personal data, you will have to apply the principle I told you about, and to find a way to apply the principle for your processing. Nevertheless, you can find specific provision about biometrics in national law. But since there is no harmonization at the European level, there are a lot of differences. I think we can find three different categories of national laws. The first one remains silent regarding biometric data. You won't have any definitions, you won't have any specific rules. It will be as for the European directive. So, for instance, it's like that in the Netherlands or in Belgium. In those countries, if you want to implement biometrics for physical access control in your company or for payment, what you can just implement biometrics, make your system and your implementation compliant with the general law, so principle, with adequacy, security, fair and lawful processing, etc. And you might have some control from the data protection authority, but you won't have any prior formalities. A second category of national law provides few rules for biometrics. Most of them are in the former Eastern Europe. For instance, in Czech Republic, Slovakia, Slovenia, data protection law defines what are biometric data, and will say most of the time that they are sensitive data. Sensitive data in the data protection legislation are any personal data that are related to health information, to criminal offenses, to religious opinion, philosophical opinion, and so on. The principle is processing of sensitive data is prohibited, except if the exception applies. One of the exceptions is, of course, the specific consent of your data subject or the authorization by law for very specific cases. Otherwise, you won't have the right to process those data. In France, it's a bit different. The law does not provide any definition, surprisingly.
Excuse me, sir. You forgot to go ahead with your slides.
Yeah, I know, I'm a lawyer. It's old school, so I don't have any slides, just paper.
Okay, only one slide.
Only one slide, then you can find me on internet.
Sorry.
Thank you. So, in France, well, as I was saying, the law doesn't provide any definition. We don't know what are biometric data. However, what we know is when you want to process biometric data to identify a person, you should get a prior authorization of the French Data Protection Authority. It means that before any implementation, you should go to the CNIL in Paris, present to them your project in all the way. It means the technical specification of the system you're using, how it will be organized in a retail, for instance, or in your company, who is going to supervise the implementation. And they will say, after a few months of reviewing, whether they allow it or not, and how they might also limit the implementation. Despite what is saying often, you don't have proper guidelines from the French DPA. You won't have a regulatory document in which you can check whether your system can be compliant or not, could be accepted or not. What you can do is to take all of the authorization and look at why they have been approved or not. But despite that, except that, from that, you don't have any guidelines. The French DPA is now working on those formal guidelines. However, we are still waiting for them since a few months now. We hope to have them before the end of the year. Let's go to the third category of national law, which provides regulatory guidelines for biometrics. Here, the best example is Italy. Until last year, the law was exactly the same as in France. When you want to process biometrics, you should go to the DPA. However, because of the evolution of biometric use and the increase of biometric devices, the Italian DPA, the Garante, has decided to have a less formal approach, let's say, and to be more, to make the implementation of biometrics easier. So they have taken regulatory recommendation saying that if your system complies with all of the requirements set, then you won't have to get the prior authorization. If one requirement is not met, then, as in France, you should go to the DPA and present them all of to present them your project of implementation. The conclusion, as you have noticed, is there is no real law on biometrics for business corporate use. To be compliant, you will have to look at the general principle and to apply them to your system. That might be very burdensome if you don't have a lawyer in your company and an engineer capable to say, well, that general principle could or should be applied with these technical specific capacities or measures. Finally, for your business, you're facing a lot of legal uncertainties because depending on the implementation, your technology will or won't be accepted by a DPA, or for an implementation can be accepted in one country in Europe and won't be in another country. So how do you do to sell your technology, or as a service provider, how do you do to implement a technology in different countries in Europe? That's, I think, a big question. Now, I would like to go on the second part of my presentation. How can we build trust and confidence in biometrics since we don't have any recommendation? In other words, how to comply with data protection law and how to comply with your users' expectation. I think we need creativity. We need to translate into code, into technical and organizational measures, the general principle I told you about. We need to build and to design a compliance system. This is what we do at Natural Security. Based on the research that have been done by universities, by DPAs, in the state of the art, we have designed a standard for biometric authentication that take into account and mitigate the risks related to privacy. On the one hand, we have implemented technical measures in our standard, and we have developed, on the other hand, tools and an ecosystem with organizational measures. Let's speak about the first part, the technical aspect. What you want to do when you're processing biometrics and you want your system to comply with data protection law is to avoid databases. They represent a risk that endanger your users' privacy. Why? Because when you put many biometrics combined with name in a database and there is a security breach, all of the data stored in the database can be stolen. However, if you go for a personal device, as we do in NationalSecurityAlliance, everything is kept under the control of the user, and if one device is compromised, that shouldn't happen, but it always can, the other devices are not compromised. With this aspect, you can meet the security principle, the retention principle, adequacy principle, because the user will keep everything under his control. Moreover, you shouldn't store and compare raw biometric data, but templates. Why? Because in the literature, in science, there is some research saying that raw biometric data may reveal health information, for instance. First, if you do raw data, it will be considered as sensitive data, as I said before. And moreover, you will be matching and storing and analyzing data you don't need to perform an authentication. Anything you need is available in templates. So you should collect the raw data, convert them directly into templates. Here, you will meet the adequacy principle, only processing necessary data. In addition, in our standard, as you have seen before, thanks to the previous presentation, two devices are communicating with each other, the remote reader and the personal device. We have secured the communication between those two with first a mutual authentication of each device to be sure they are genuine. So you won't have hijacked device trying to collect biometrics captured by the reader, for instance. And everything is transmitted from a device to another through a secure channel. Here, again, you will meet the security principle. Finally, if we go a bit deeper into the technology we have designed, and you take the personal device, on the one hand, you will have the biometric data stored, and they are not stored combined with any names, any surnames, any ID. You have biometric data. You don't know whose biometrics they belong to. On the other hand, you will have all of the service data, which could be payment data for payments or number you need to do physical access control, and so on. When the service provider of the biometric authentication will compare and match the biometric data, he won't know anything about the service data that will be transmitted afterward to the service provider. And a service provider, like a bank, won't know anything about biometric data or the data useful for the other service provider. So all your personal data inserted and stored in the personal device are isolated from each other. If one is compromised, the other won't be compromised. That's very important, and we call that anonymous identification and management of multiple identity. And if your personal device is compromised, you can go to see your service providers and say, hey, please, can you change my ID numbers or my payment account to isolate the consequences of the breach with your personal device, let's say. But for many reasons, technical measures are not enough, especially when we're speaking about standard. How do you make sure the vendor has implemented correctly the standard when you're buying products? How do you make sure the implementation of the product is compliant with the values you may share with the alliance? And how do you promote for your customers and users the privacy-friendly device and service you're selling? Therefore, we have designed tools which, combined together, constitute a proper privacy-friendly ecosystem. First, we have the privacy rules. Second, the certification scheme, and then the collective trademark. The privacy rules are voluntary commitments. When you're a service provider and you want to get either to manufacture or to use technology based on natural security standard, you can sign our commitment and you will say, well, when I will process biometric data with technology that is based on natural security standard, I won't do any database of biometrics, I won't do any tracking with the biometrics, and I will use approved product. That's another point. When you want to sell product to a service provider, for instance, you can get your product based on the natural security standard approved by the alliance. Then the service provider is guaranteed that the product is getting has incorporated all of the privacy by design measures we have elaborated in the standard. And finally, when you're committed to the privacy rules and when you are using approved product, you can use the collective trademark, which is the green hand with only 3 waves on your product, like a label or a seal. So your customer or any customer will be able to do the difference between a similar product or service that is not privacy friendly and your service or product that is privacy friendly, thanks to our ecosystem. Of course, once you have implemented all of these measures, it doesn't mean your implementation, the project you want to run, is fully compliant, because it may depend on some specificities, depending on the purpose as well, or the population you're reaching. However, you've done a big step forward to be complying with data protection law. And what is very important to understand is a system won't be 100% compliant. However, what is important for a DPA is your intent to comply with the law. So if you can be able to prove you have implemented measures to protect your users' privacy, it will be a very good point for you. And doing the collective trademark, privacy rules, implementing a privacy by design standard is something very important for a DPA. Finally, and I will conclude on that, as I said, a technology is not compliant with a law. It depends on the implementation. In the Alliance, the Legal Advisory Committee can help you to define, to design your implementation, your project, to make it compliant with data protection law. We can help you through the DPA procedures to get authorization when you need one, especially in France. and we can inform you, propose you some solutions. Well, that will be the end for me, and thank you for being here.